Hey, Emily, this is Damon. Go ahead and start the broadcast.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and happy Valentine's Day, everyone. This is Damon Circos. I'm chair of the State Board of Elections, and I'm going to convene our meeting. Before we get started, let's go ahead and make sure we have all of the board members on the line. Mr. Black, are you there?
Present.
Raymond, are you there?
I'm here.
I'm here. Mr. Carmen, are you there?
Yes, sir.
And Dr. Anderson, are you there?
Yes, I am.
Okay, we are all here and present. We'll begin, as we customarily do, with the reading of the Ethics and Conflict of Interest Statement. In accordance with the State Government Ethics Act, it is the duty of every board member to avoid both conflicts of interest and the appearance of a conflict. Does any board member have any known conflict of interest or the appearance of a conflict with respect to any matters coming before the board today? If so, please identify the conflict or appearance of the conflict and refrain from any undue participation in the matter. Any conflicts? Hearing none, we'll move forward. We will now move to the next item on our agenda. So we have a preliminary consideration of county board member complaints. As you all might be aware from a procedural note, the first thing we do when we get a board member complaint is we make a determination here based solely on the documents in front of us and the four corners of those documents, whether or not there is enough in that complaint to move to a full evidentiary hearing. If we were to move to a full evidentiary hearing, we would notice all of the particular, both the respondent and the complainant, and they would have an opportunity to appear before us. We will start with the pool complaint. It's against Mark Barrasso on the Chatham County Board of Elections. Again, this is the pool complaint that you all have in front of you and is obviously available on our website. Mike A. Pool is the complainant, and Mark Barrasso is the board member against whom the complaint is filed. Is there any discussion?
I have a question for Caitlin.
Sure. Caitlin's right here.
Okay. Caitlin, the question is regarding the rules. I'm looking at 08 NCAC 03.0105. Can you hear me?
Yes.
Okay, under scope. And I've been reading what it says under scope of an investigation. Particularly where it says the board may on its own motion investigate any matter listed in Rule .01021 through 3 of this section upon receiving any additional evidence as a result of investigating or hearing said charges. My question is, under the rules, if this board on its own motion can expand or request more evidence or information, is that correct?
So, yes, that's correct. So what the rule lays out is that the board cannot go beyond what is outlined in the complaint itself unless the board takes affirmative action to expand that scope and to ask for an investigation. And the board has independent authority to appoint and remove the county board of elections members. And at least in one instance in past years, the board on its own conducted an evaluation and removed a county board of elections member in Rowan County due to offensive comments that individual made. Of course, right now before you is a complaint as filed, and so the board would need to make some additional determination if it was seeking to move outside of that complaint.
Okay, thank you.
Does that answer your question, Ken?
Yes, it does.
This is Stella Anderson.
Dr. Anderson, proceed.
Yes. When I look at the two pieces of the complaint before us, the first being the
Chatham for All Facebook page. I see that as issue advocacy, which board members are free to do as long as those issues are not ballot referendum items, certainly not advocating for or against a candidate. So I don't see that as prohibited action or behavior. In terms of the second piece of the complaint, the statement made about the, quote, first judge, I see this as no candidate being named, no statement for or against the candidacy of anyone. I don't believe that that falls within the purview of 163.39, prohibiting political speech as defined in that statute. So I do not see cause for continuing consideration of this complaint.
Any other discussion or questions?
Mr. Chairman, again. Go ahead, Jim. I find myself again in a horrible situation because the behavior, although it doesn't reach the level where I think it should be before us, I think board members again need to put a little more thinking into their responding to things online.
I would agree with that wholeheartedly.
Mr. Black, you had a question?
Well, yeah, this goes back to a previous comment that I made where I think that any board member, county board member, should probably get off of Facebook because it results in things like this. While I know this is the main complaint against him, I guess. Mr. Barroso has some history in Chatham County. But I guess, based on what within the framework of what we're to decide, that probably doesn't come into play. Although at some point, I'd like to see us become a little more active in some of this because, it seems like we only embolden people when we say, well, it might have been on Facebook, but doesn't rise to the level of discussing further. But anyway, I would have to agree mostly with Dr. Anderson in this case. But I would not be surprised if we see Mr. Barroso's name again before us.
Other discussion, comments?
Yes, this is Chad. Just a question. The Superior Court judge that's mentioned in this complaint, is he currently a candidate for office?
Yes.
He is.
Okay.
He is a candidate for office.
I'm gonna go ahead and ask our staff to determine whether or not the complainant is a candidate for office. The complaint says that they're referring to a Superior Court Judge, Casey Visor.
Yes.
I'm gonna go ahead and get that answer from our staff. Is there a Superior Court judge named Casey Visor who is a candidate for office?
Yes, sir. That's correct. On our list.
Thank you. So the short answer is Superior Court Judge Casey Visor, who is mentioned in the complaint, is a candidate for office.
Well, in that case, I would have to support a hearing on this now because he's a current candidate for office and we have a board member making a disparaging remark against a candidate for office.
I would concur.
I'm not going to support your motion, Ken, not because I don't understand what you're trying to do, but it seems to me that we would need the Facebook complaint itself or the public statement to mention the candidate, and I do not see that in the four corners of this document. So,
Don't we have I'm sorry, go ahead, Mr. Chairman.
no, please, David, I said I will not be supporting the motion.
Okay, I would be supporting the motion because, I think it's plain that there's a Facebook conversation between Mr. Poole and Mr. Barroso regarding this judge.
Who is a current candidate for office. And again, like Mr. Black said, we're beginning to see the same names come before us over and over again. And simply dismissing these matters and these issues, it appears to be emboldening them to act inappropriately. So I think we have to do more to, for lack of a better term, rein in some of these board members.
Can I ask a question? I know the assertion has been made that we may well see Mr. Barroso's name come before the board again, but do we have a previous complaint about Mr. Barroso prior to this complaint that we have in front of us?
He was only appointed to, this is Mr. Black, he was only appointed to the board last February.
In
But
February?
the answer
Okay.
would be no.
I think Mr. Barroso needs to take notice that he has come right up to the line, suppose, and should exercise very much caution to make any statement about someone that appeared to be someone that's a candidate for office. Had I not seen Mr. Poole's statements in the complaint, and I just looked at the Facebook post about the judge, I would have had no idea what judge he was talking about, or whether or not this is somebody that's elected or seeking election. So that's the problem that I see with the evidence that is before us. The evidence is not of a named candidate for a statement for or against a particular specific candidacy.
Dr. Anderson, this is Dan.
Having said that, he needs to be extremely careful. He can advocate on issues all that he wants to, but when he starts making comments about, quote, judge and agreement with or disagreement with judges' rulings, then that gets into a different territory than advocating on an issue on its own.
Thanks, Dr. Anderson. I'm looking at the statute right now, and I want to make sure that we're doing as the statute directs us. And the statute seems pretty clear to me that no individual subject to this article, meaning no county board member, shall make written or oral statements intended for general distribution or dissemination to the public at large, supporting or opposing the nomination or election of one or more clearly identified candidates for public office. Dr. Anderson, I'll agree with you that I think if it were up to me, every single county board of elections member would be off of Facebook and off of Twitter and would conduct their activities accordingly. But the statute only prohibits them from opposing the nomination or election of one or more clearly identified candidates for office. I do not believe that that is what happened on this Facebook page, and as such, I will be voting not to move this to an evidentiary hearing. And with that, Dr. Anderson, do you have a motion?
Yes. I would move that the state board dismiss the complaint against Chatham County Board Member Barroso.
Is there a second?
I'll second, and I like the second with a statement.
Go ahead and proceed with your statement. Moved and seconded?
I agree with. I'm sorry.
I'm sorry, just clarifying that the motion has been moved and seconded and that you're recognized for discussion.
I just want to make a statement that I agree with both Mr. Black and Mr. Raymond. However, I'm being restricted by the statute makes it hard for me to not support this motion, and that's why I second.
Outstanding. Any other discussion? Okay, hearing none, I think I should probably call the roll on this one. The motion is to dismiss the complaint. Dr. Anderson, how do you vote?
Aye.
Mr. Carmen, how do you vote?
Aye.
Mr. Raymond, how do you vote?
No.
Mr. Black, how do you vote? Chair votes aye. Motion carries 3-2. Okay. Next item of business is the Smith complaint. Charlotte Smith filed a complaint against Patricia Shepard. Everybody has that complaint in front of them. Is there any discussion?
Mr. Chairman, are we discussing both complaints on both?
I think we should go one at a time. So we'll start with the complaint by Charlotte Smith against Patricia Shepard, and then move to the other one.
Mr. Chair, this is, somebody want to go first?
Yes, I'll go.
Then go right ahead.
Okay. Mr. Chairman, I'd like to make a motion that the board investigates additional matters based on the board allows additional information and evidence to be brought before it concerning this matter based on NCAC 08.0105.
All right, let's make sure I got your motion correct here. In fact, I'm going to have Caitlin read it back if she would.
So I have the.
Do you need me to repeat it?
Yeah, go ahead and repeat it, Ken. That'd be great. Thank you.
Okay. My motion is to allow additional evidence and information to be submitted regarding this matter.
All right, so this is a procedural question I have for you, Ken. Are you saying that we move to an evidentiary hearing?
No, I'm saying that we allow additional information to be per the rules of NCAC 08.0105. So I understand it correctly. We can allow additional information regarding a matter to be submitted.
All right, so let's see if you get a second, and then if we see a second, we'll see if we need to have some discussion. Is there a second to Mr. Raymond's motion?
David Black, second.
Okay, it's been moved and seconded. Mr. Raymond, can you explain a little bit about what your motion intends to do?
Well, like I said in the previous matter, what we have before us is an individual, and the next one is another individual, same board. These names come before us over and over again. And I think we have to take steps to resolve these issues for the sake of the voters within this county, within Bladen County, or they're going to continue to come before us during this very important election year. And I believe we have to, it seems to me as if every time we dismiss a matter that comes before us, they haven't learned their lesson. They proceed and they continue down the path that they're going. This time, I think we have to do something. However, I think we need to allow for additional information, additional evidence to be submitted so that we can deal with the matter and the questions of these board members once and for all.
Who would you propose?
I'm a little confused.
Yeah, go ahead, Jeff.
I, based off of what you're saying, Mr. Raymond, it sounds like the only way we can resolve this is by removing that board member, because the people are going to continue to complain or submit complaints until that solution is put before them. I don't think we as a board should be pressured into. I just need more clarification from you, because I'm totally confused on why we're.
Okay, I'm simply making a motion that this board allow additional information regarding this matter to be submitted from the complainant.
From the complainant.
I'm asking, what's your basis for that?
This is a totally different issue.
Okay.
Hold on a second, Ken. I think I'm hearing information from other folks who are not on the board. If you are not on the board, unless you're recognized by somebody, basically me, to speak, please do not speak. Ken, go ahead.
My basis is the history of this board, the recent history of this board, and I think for them to go forward and deal with and handle the elections this year, we need to hear more. We need to hear more of what this individual has to say.
So let me ask you this, Ken. One, I am not unsympathetic to the notion that we've got some serious issues in Bladen County. And I believe that those issues extend beyond the two members who have complaints before us today. I share your concern. My challenge here is how best to move forward with that. I mean, certainly we could allow, we've already allowed as much evidence as the entire universe allowed before us. All we need to do is get an actionable complaint. So I think the better way to move forward is to look at the complaint before we decide whether or not we want to make a move to an evidentiary hearing. I'm going to ask Caitlin to be recognized to offer some clarifying remarks.
Yes, thank you, sir. So if I can just clarify what that particular rule is regarding scope. If the board today voted to schedule an evidentiary hearing, the board could take any additional evidence related to any of the matters that were already raised in the complaint. If the board is seeking to broaden the scope of the subject matter of this complaint, I believe it would be necessary to identify which areas outside of the complaint the board is seeking evidence in, so as to put the parties on notice as to what matters they need to address at the evidentiary hearing. But today the board is limited to considering what's in the complaint, and it could broaden that at the hearing, but it would need to identify which particular areas it was seeking additional evidence on.
Okay, so I would have to identify the areas for which I'm asking for additional evidence. Is that correct?
Yes, Mr. Raymond, I believe that would be necessary because otherwise it would just be proceeding to an evidentiary hearing as usual, and you would have witness testimony and any documentary evidence regarding what's already been raised in the complaint. If there are other issues that are not raised in the complaint that you address, I think it would be necessary to identify those.
Okay.
Hold on a second. Let's Jen finish, and then we'll go ahead and go to Dr. Anderson.
Okay, well, in that case, I would like to move that this board receive additional information regarding the information submitted regarding the board member violating the open session, the open meetings law of 143-318.11, and the section where the complainant alleged that the board member. Well, that's all. I'll leave it right there. a violation of open meeting law and we got on 8/11.
Ken, hold on just a second. We got a procedural question. We had a motion in front of us, and now we've got a second motion. So I'm going to pause and ask Kelly and Caitlin. Procedurally, I think we need to close out either your prior motion. So let's do that. We'll take a vote on that, and then if we wish to introduce an additional motion, we go from there. Does that sound like a reasonable way to proceed?
That's fine.
All right. Caitlin, can you?
So the first motion was to allow additional evidence and information to be submitted regarding this matter. The second motion was to allow additional evidence and information regarding the possible open meetings law violation. Am I understanding that correctly, Mr. Raymond?
That's correct.
Okay. And are you wishing to withdraw the first motion or just have a vote on both of them?
I'll have a vote on both.
I don't think he can withdraw because he was moved in second.
You're right. So you would just go in the order of precedence and then.
So the first motion we'll consider is Ken's what I'll refer to as the broader motion. It's been moved and seconded. Mr. Black, how do you vote?
I vote for the motion.
Mr. Raymond, how do you vote? Mr. Carmen, how do you vote?
I don't see how the motion is appropriate this time, so I'd have to vote no.
Dr. Anderson, how do you vote?
I believe the motion is not appropriate. Either, I vote no.
Chair agrees with Mr. Carmen and Dr. Anderson that this isn't an appropriate motion, and so he votes no as well. Motion fails 3-2. Okay. Let's pause for a second here and get a little clarification on what our charge is today, and then I'll entertain any additional motions. And you might want to make yours at that point if we get there. So let's pause and kick it over to our general counsel to talk a little bit about procedurally what we're up to today.
So the consideration for the board initially is whether to dismiss the complaint or whether to find that there is prima facie evidence of a violation. At that point, if the board wants to limit what is the scope of that hearing or expand the scope of that hearing, it can do so. And that could be that could be one motion or it could be separate motions. But an initial determination needs to be made about whether the complaint itself includes sufficient information to allege a prima facie violation of the law or one of the other issues identified in the rule, which includes breach of the duty imposed by Chapter 163, or participation in irregularities, incapacity, or incompetency to discharge the duties of the office. And Black's Law Dictionary defines what the meaning of prima facie is, and that is sufficient to establish a fact or raise a presumption unless disproved or rebutted. And so that means that you look at the complaint, look at what has been identified in the complaint, and say if none of that information was rebutted, all of that information is true, would that be sufficient to create one of the things prohibited conduct? So that initial determination needs to be made by the board about how to proceed from where we are with just having received this complaint and nothing else.
So Ken, let me see if I can help out here with something. And this is my estimation, and obviously we only act as a board. In these two complaints, I do not see enough evidence, even if everything is in them is true, to warrant a removal. That being said, I am interested in getting to the bottom of some of the concerns alleged about open meeting violations, conduct of meetings, etc. I would like to dispense with these two, and then I would like us to work collaboratively with staff to figure out how we can get some improvement to the actions of all 5 members of the Bladen County Board of Elections, because I've got some concerns.
Chairman Tracosta, This is Stella Anderson. I have a couple of brief thoughts, comments about the complaint in front of us. I would agree that I looked at the complaint in front of us from the standpoint of I'm going to assume all of the charges, all of the claims of Charlotte Smith are true. And they are, at least as it relates to Patricia Shepard, twofold. One concerns the, what I would call, unnecessary flap about saying the Pledge of Allegiance. And I want to make clear, I want us as a board to make clear, we should not see another complaint centered around saying the Pledge of Allegiance at their meetings, because saying the Pledge of Allegiance is not a requirement or a duty of statute or rule. This is a decision that presumably the chair will make, has made, and each individual member can make as to whether or not they want to participate if it's going to be said at meetings. The practice differs across all 100 counties. So I would like for us to dispense with the business about a complaint that there's something wrong in not saying the Pledge of Allegiance at the meeting. There is not. The second part of the complaint is more concerning. Ms. Smith, who I believe is a reporter or a commentator on Bladen Online, claims to know what was or wasn't discussed in the context of a closed session. So to me, this points to a larger problem that, as you said, is really about questions for all 5 board members and whether or not, I don't have any idea how Ms. Smith for Bladen Online knows what or was not said in closed session of the Bladen Board of Elections. I can surmise how that might be, but nonetheless, it seems that there are issues around the appropriate conduct of closed sessions and issues around the open meetings law. So I think all 5 members need some additional schooling here that specifically speaks to the requirements and the proper conduct of closed sessions. And I don't see that as an issue that would relate only to Patricia Shepard or the chair, Luella Thompson. This means that it relates to all 5 members. If someone on the board in the closed session had an issue with the discussion straying from the lawful purpose of a closed session matter, they didn't need to bring that to Charlotte Smith. They needed to bring that to us. They needed to bring that probably to Caitlin Love as general counsel, who could have advised all 5 board members about further matters of the open meetings law, the requirements and the conduct of closed sessions. So I don't see that this is wrongdoing or improper conduct on the part of Mrs. Shepard or the chair, Luella Thompson. I see this as a broader issue that points to all 5 board members doing a better job with how their meetings are conducted and doing a better job in terms of staying focused on their specific responsibilities. And I would argue that if they all pledge to stay focused on their actual duties and responsibilities as board members, that's the only way in which they're going to instill confidence that their board of elections is going to fairly and impartially perform those tasks on behalf of all voters in Bladen County.
Dr. Anderson, do you have a motion?
Okay.
I'm sorry, Ken. Before we go to that motion, let's go ahead and go to the motion, and then we'll have some discussion from Ken. Ken, I'll make sure you get an opportunity to discuss.
I would move that the state board dismiss the complaint against Bladen County Board Member Patricia Shepard and Chair Luella Thompson, and further move that we direct the State Board staff to meet with all 5 of the Bladen County Board members to provide further instruction on the requirements and proper conduct for closed session.
Is there a second?
I second.
Okay, it's been moved and seconded that both Luella Thompson and Patricia Shepard have their complaints dismissed. And I intended to take those one at a time, but now that they're both in front of us, definitely want to have discussion on both of those. And Mr. Raymond, I'll give you the first word, certainly.
Okay. Thank you, Mr. Chairman. I believe that a straight dismissal of these complaints, I think we need to take a deeper look. These names have been before us in the past several times, and I think a straight dismissal will only embolden them to continue the way they've been doing how they've been doing.
Mr. Raymond, this is Damon. Would you support if post this motion? Would you join me in supporting a direction to staff to train up all 5 of those Bladen County board members on the conduct of meetings and the appropriate confidentiality of closed sessions?
Mr. Chairman, David Black, could I offer a comment?
Sure.
I've been on this board a year, a little over a year now, and I learned a hard lesson about closed session meetings about a year ago, and when I asked the current legal counsel at the time regarding closed session rules, he told me that closed session does not mean that you can't discuss what went on in closed session. And while and that was even backed up, by the School of Government at University of North Carolina, even though in one of their in one of their discussions regarding open meetings, they said that while it's not illegal for someone to reveal what went on in closed session, it might be inappropriate, and it might not be the best thing to do, but it's not illegal. And so if someone came out of a closed session meeting and proceeded to tell someone about it, it might not be appropriate, might not be the best thing to do, but according to the School of Government, it's not illegal.
That would not be my understanding of our requirements as board members. Perhaps Caitlin would speak to that issue.
Well, if you go back to the School of Government, I think they have a website, Shepherd's Rules or something like that. It was plainly discussed in that particular article.
Let's go ahead.
The School of Government.
Colonel versus General Counsel loves to remind everybody what the obligations under closed session are and are not.
Thank you, Mr. Chair. So I would advise to look to the particular reasons for the closed session as to whether those matters could be discussed. The statute itself does not direct to whether board members may publicly reveal what was in the closed session, so it would depend on the reasons. For example, if the board is in closed session to receive advice from legal counsel regarding possible litigation matters or ongoing litigation, it would not be permissible for an individual board member to break that attorney-client privilege without the board having to know. It is the board that is the ultimate client and not any particular board member. There are other matters that may be discussed in closed session, personnel matters, where there may be other statutory prohibitions on revealing that information to the public. So again, it would depend on the particular reason
important to recognize that boards can't go into closed session but for a very specific set of reasons. One of the many, many reasons that I think it would be good, and I hope I could get some support from the rest of this board, to direct our staff to ramp up their efforts to educate, particularly the Bladen County Board of Elections, but certainly all of our Board of Elections, on these matters. I agree with Dr. Anderson that if you look at the four corners of each of these documents, there is not enough here to warrant removal. I do also agree with, I think, everybody on this board that we are a long way from making sure that we've got a fully functioning, very capable Bladen County Board of Elections, and they need to get their affairs in order right quick because we're in the middle of early voting. Any other conversations on this matter?
Yes, Chairman. This is not about being threatened with arrest. It's about being threatened with arrest after saying the pledge. It's not about the board members saying pledge. It's about the citizens being threatened with arrest.
Emily, can you cut that line? I don't know that you would do that, but please stop.
Okay, I'll go ahead and call the question. All in favor of Dr. Anderson's motion, we'll go ahead and do this by roll call. And we'll start with Mr. Carmen. How do you vote?
Mr. Chairman, please, could we review the motion?
Certainly to restate it.
Yes,
Yes,
please.
sir, I'll restate it. And included both complaints, if that's okay. I moved that the state board dismiss the complaints against Bladen County board members Patricia Shepard and Chair Luella Thompson, and further moved that we direct state board staff to meet with all 5 of the Bladen County board members to provide further instruction on the requirements and proper conduct for closed session.
Motion has been restated. We'll call the roll. Mr. Carmen.
Had to get off the meeting. Aye.
Mr. Black, how do you vote?
A resounding no.
Mr. Raymond, how do you vote?
No.
Dr. Anderson, how do you vote?
Aye.
Chair votes aye. Motion carries 3-2. Okay. Before we conclude our business today, I want to remind everybody listening that the primary election is not just the presidential election. The primary election in North Carolina is on March 3rd, and early voting is from now until February 29th. We're in game season, folks. It's time to make sure that we get our work done and make sure that this election is secure and accessible for all. If I'm not hearing any other comments from board members, I'll go ahead and adjourn the meeting.
Chairman, may I say something?